Good evening, everybody. Welcome to our next event in the online series organized around interactive entertainment law review. This is a pre-publication event for the latest issue, 4.2. And we have here tonight with us one of our authors, Emmanuelle Sarlangue, and another speaker, another expert in the area, Rosie Burbidge. This event is titled Design Intelligence, and we will be discussing registered designs in the context of video game industry, both in theory and in practice. Let me introduce our speakers today. Emmanuelle Sarlangue is an associate in Ellen and Overy in Paris in their intellectual property litigation department. She is part of the firm's gaming practice and regularly advises actors within the video game industry. The key areas of her practice are copyright, trademarks, and obviously design litigation. Emma is also an alumni of the Interactive Entertainment Law module at CCLS. And in 2020 and 2021, due to COVID postponements, she also represented Queen Mary University and CCLS in the moot competition organized by the Games Industry Law Summit at Vilnius. And together with her teammates from Queendom Hearts, won the best memorandum for respondent. We also welcome tonight Rosie Burbidge, who is an intellectual property partner in Gunnercooke's London office. She is well known for her work within the gaming and fashion industries and for her deep knowledge when it comes to intellectual property rights. She takes rights such as trademarks and designs from registration to litigation and all the way back again. Her book, European Fashion Law, has been described as the best industry-focused legal textbook I've seen by lawyers at major UK fashion businesses. A similar book is in the works for the gaming industry, and we can't wait. Rosie also has a website, rosieburbidge.com, where you can read about all the latest intellectual property developments. So again, thank you both for being here tonight, for making the time to be here with us. Let us go straight to the topic. I just wanted to open with a statement or a point that Emma, that you make in your article, that while the video game industry obviously allocates a lot of effort and resources to produce aesthetically pleasing and functional games, something that is supposed to visually look impressive, something that design rights are obviously tailored to protect and enable commercial exploitation. Only very few video game companies actually take advantage of digital design registration. Why do you think that is the case? Why there's possibly this kind of distinction between theory and practice? Over to you.
Yeah, thanks a lot for the intro, Michaela, and for having me here. It's a real pleasure. Yeah, that's pretty much exactly how I came upon writing about video game about design rights in the video game industry, which may sound like a very niche intersection. It was coming from this idea that the video game industry allocates a lot of resources to create aesthetically pleasing games, and because that's one of the key differentiators when you're looking for a game. You're looking for a game which navigates well, which looks nice, and so on and so forth. And what the IP right to protect the appearance of a product, design rights, isn't used in the video game industry. You barely ever hear about it. And it's not as if the video game industry doesn't rely on intellectual property at all. The video game industry is one of the top creative industry which relies on trademark and copyrights. It's just that it doesn't specifically use designs. I think that one of the reasons which I explore in my article is that design rights is an intellectual property right that's perhaps not very well understood and not very well known. First of all, it's true that it has maybe like, you know, shinier brothers called copyright, trademark, and patents, and you kind of forget about poor little design right. And in my opinion, design rights are immensely undervalued in a number of industries, including the video game industry, because they're not thought about and because just it doesn't come up when you think about IP. You think about the free big rights. You don't think about design rights. And so for an industry where most of the actors are smaller studios that don't necessarily have the in-house capacity of having legal advisors, they're not going to think about design rights because design rights are not known to the general public. I also think that there is a number of problems that I think we're going to address a bit later with Rosie on the system, the European system that we have, so community registered designs. For instance, that the fact that it's not very clear from reading the directive and the regulation that you can actually protect things like graphical user interfaces and, you know, all those virtual designs, and the fact that there are a number of procedural aspects that also complicate a bit the task of registering designs in the EU. But those problems could be easily overcome, in my opinion. And it's actually the perfect time to discuss this because, you know, the EU Commission is in the process of evaluating the whole design framework and taking input from loads of different industries. Unfortunately, the video game industry was not part of this discussion and didn't really make their voice heard, which is a shame in my opinion. So yeah, I think that design rights are just generally a right that's not very well known, and the video game industry, like many other industries, doesn't take full advantage of it, which is a shame because they have a lot of advantages, as we will discuss.
Thanks, Emma. I want to ask Rosie, do you think there is a specific aspect or feature or something that could be tweaked to make designs more of a focus when it comes to IP strategy of video game companies? Is there one thing that could be changed to make a big difference? If on one hand, in theory, designs you know, tick all the boxes in terms of being suitable to protect specific aspects of video games, and yet they're not being really heavily relied on. They're not the strongest sort of tool in the toolbox of many video game companies. Do you think there's something simple that could be done to change that?
So a big question. I think I will start off by thoroughly commending Emma's article because it's extremely thorough, really well written, really easy to follow, and really goes into all of these different questions in a fantastically clear and logical way. So it's a bit lengthy, which might seem a bit daunting, but in all other respects, it is, you know, really worth the read, worth the time investment, and I'd really commend it to anybody. So one of the things that Emma touches on, I mean, I don't think I'm going to solve the design policy problems in a short webinar, but I think that the article does touch on some really good ideas and solutions. One of which obviously is to do with the choice of design. I think, well, there's two things. First is people knowing that designs exist in the first place. And that's an education problem, which I think we are helping to solve maybe today. And also it just requires engagement, both I think from the various intellectual property offices, but also from the industry to maybe take a bit more, pay a bit more attention and phrase it as an internal thing. You know, say for example, if Yuki in the UK really got behind this and shared it on a more regular basis, I think then maybe members would be much more aware of the existence of this right. And the same, as Emma points out in her article, one of the issues, maybe one of the barriers to entry, is that quite a lot of the players in the gaming industry are relatively small, or certainly not at the sort of large international level of, say, some of the major copyright owners. And that might be another reason why there is this reticence to invest the time. I think, from a sort of identification of the design's point of view, it's actually much simpler for the gaming industry than it is for some other industries like fashion, where identifying and preparing line drawings is a really expensive part of the design process. It's often a lot cheaper to identify, say, for example, key icons and to put them into the correct format for registration. And that, in some respects, is a bit of a missed opportunity if either there was an education process internally, whoever's in charge of IP, becoming more familiar with the options, or a regular review with an external provider to identify, what new games are coming out, what are likely to be the key features, and going through that process. That's a really valuable lesson, which I go through with some clients who are keen to embrace designs, but it's hard to get over that initial sort of unknown hurdle, where I think people are very comfortable with the concept of trademarks, but it obviously that took quite a long time, and eventually I'm sure designs will become something that people are a bit more comfortable with, but I'm sure that journey, that will take time too. And again, actually, as Emma says, there's some very good stats. I love some stats. And she points out that there has been this increase in the number of logo type filings. So it does seem like there is this slow progression and awareness that these types of designs exist, that it's not just for three-dimensional products. So I would say overall, we're moving in a positive direction, and I don't know that necessarily the system needs to change hugely, but the features of the system can be embraced to a greater degree.
And I'm definitely glad that we are part of that process and on that journey, to some kind of to make a positive change in that direction. You mentioned design choice, and I want to talk about that a little bit more, if possible. If thinking about video games as complex digital products, which features or aspects or attributes of video games do you, either of you, consider most suitable for design protection? Where do you think the focus of video game companies and industry actors should be, and when thinking about this particular IP right?
I think Rosie wrote an article as well about designs in the video game industry, which I read and I really appreciated, which gives perhaps a more practical look upon what exactly you can register. And I think, correct me if I'm wrong, but in her article, she gives examples, obviously, of graphical user interfaces, which is perhaps the one which is currently being registered the most by actors like King, but also other things that you may not think of, such as the characters of the game, which can be perhaps most useful when you think about merchandising, as well as the graphical elements of the game, the map. You have a brilliant example of a registered community design, which takes different levels from a very bare map to quite a detailed three-dimensional map in which the player evolves in the game.
That's a very good memory that you have. The article came out a few years ago, so it's great that it's still being considered. I completely agree with that. I also think the kind of the chunky type approach of thinking about the different, not just in terms of the levels of detail on something like the map, but also thinking about registering, say, a character as a line drawing in grayscale and in color is a really good way of providing different layers of protection. when you're thinking about how infringement might occur, and also so that's helpful both from the infringement point of view, but also in terms of if there are some early examples that might bring into question the validity, which I'm sure we'll touch on a bit later, that being one of the big issues with designs. But by having different sort of slices of the design registered, you do end up with a much stronger package. And a really important feature of the design system that not a lot of people may be aware of is that there is this huge economies of scale in terms of the pricing. So the more designs that are registered at once, the cheaper it is. So for example, for a UK design, which I now am familiar with, having not really registered them previously, people would file a community design because it covered the UK and covered 27 other member states. So of course, that's what you would go for. But now people are obviously having to register both in the UK and in the EU to get the same level of protection. But anyway, the costs in the UK, I think, are quite a good illustration, because for the first design, it costs £50 in terms of the UK IPO fee. But then for the next 9 designs, you're only paying an extra £20. And then for the next 10 designs after that, it's only another £20. So, you can really be quite granular and not be incurring vast amounts in fees. And that is a feature that, again, I think a lot of people don't even know exists. And if they do, they don't really take full advantage of it.
I think that's a really good point. And it sounds like this kind of approach where you can register sort of different layers of the same map or character enables you to capture almost the dynamic feature of video games, where, some of the aspects, the visual aspects may not stay the same, and kind of being able to identify the different layers or the sort of the building blocks of what they consist of, as you say, strengthens the protection afforded. One specific application or impact of design rights and design protection can be fighting against game cloning, or trying to establish a measure, efficient and cost-effective measure when it comes to game cloning. How would that look in practice, or how we can see this impact in practice, relying on designs when building an overall IP strategy and trying to specifically address issue of game cloning?
So I mean, maybe I'll start. One of the issues with clones, obviously quite often the name is the same, and then I think going down the trademark route is often the best option, because it's something that if you're filing a takedown, people are much more comfortable with. But it's become more and more common that there isn't that similarity. The functionality and maybe some aspects are similar, but the underlying name, the actual name, is different. And having registered designs is so helpful, because in theory, I think a lot of the stores, so Google Play and the App Store, may accept unregistered rights, like an unregistered design or copyright. It's much harder to show that when you have to prove that there is this unregistered right, you have to prove ownership. Whereas with a registered design, you have this lovely certificates that you can simply show to the App Store, and it's very clear around ownership. It's very clear what the four corners of that design are, and doing the comparison is a much easier exercise. I suppose I'm thinking of this more in the context of takedowns, but that's equally applicable when you're writing a cease and desist letter. And obviously, I think a more blatant clone, you would probably go down the App Store / Google Play route. But if it was maybe something that's a little bit more complicated, and you might want to rely on several different rights, like potentially copyright as well as the registered design, and maybe unregistered designs for features that weren't selected for registration, but are nevertheless still designs in the particular game, then taking a more of an aggressive legal cease and desist or letter before action route might be preferable. So yeah, that's it'd be good to see what Emma has to say as well, though.
Yeah, I wholly agree. I think that one of the main advantages of design rights is that it's a nice piece of paper. You know, you have in front of you something that's tangible and something that you can show to the App Store and tell them, this is the right I have. This is why it's infringing. This is why this game that's on your platform is infringing my right. So it's very reassuring because it's a registered right as opposed to copyright. And I think also one of the advantages of design rights over copyright when it comes to clone games is that you see a lot of clone games in the hyper casual mobile gaming industry, which is games that are extremely simplistic, that perhaps don't have, you know, an in-depth story. They don't have amazing graphics. They don't have these amazing soundtracks, which are some of the elements that judges use to prove that a work is original under copyright law. So at least in France, it's become increasingly difficult to prove originality of those hyper-casual games. And there's also an added layer of difficulty in France because you know that we have, you know, these moral rights, this problem with authorships of companies, which is an additional layer of difficulty when you rely only on copyright. So even if you are sure that another party is infringing your game, if you base your claim only on copyright, there is a risk that the judge will not recognize it either because there's ownership problems or originality problems. You don't have those problems when you're relying on design rights. There's no considering of originality. There's no problems of ownership because it's a registered right. And so, in my opinion, that's one of the reasons why design rights address the issue of clone gaming much better than copyright does.
And do you think that's you specifically mentioned hyper-casualized mobile games, but if we look at other types of games, more complex video game products, whole environments, whole ecosystems, you know, going all the way to metaverse, which I think only this week I mentioned about 12 times. Are designs going to play a greater role? Is that where the future is? Will they be much more important and much more dominant if we're thinking about things like virtual reality, augmented reality, really complex ecosystems? How do you see the role of designs in this not too distant future? Emma, or
no, I was just going to say, I think one of the big advantages of designs over, say, trademarks is that you're not limited in terms of the categories. So this means that, say, for example, new types of technology that we might not have covered in a trademark specification, that issue doesn't arise when you're looking at changes as far as virtual reality, augmented reality are concerned. And that is one of the major advantages of the design system, that it's not linked to particular products. It's purely, although the Locarno classification might be a bit deceiving, that doesn't limit you in terms of any other particular usage. And that is hugely helpful and will give us a bit more flexibility when we're addressing how the metaverse will act in practice. Although I have to say, I think quite often it's very easy to get excited about the changes of things like, you know, virtual reality from a legal perspective, and actually quite often the transition is much more straightforward than you might think. There isn't always a need for new legislation to take into account these kind of technological developments.
Emma, do you think that the current system is reasonably technology neutral and it can handle developments that are literally on the horizon? I know that you discuss in your article, you discuss some aspects of the design system that could change, that would be beneficial if it changed. If you want to talk about that a bit more.
No, but I think generally the framework we have in Europe, which was created, I think 25 years ago or so, has adequately addressed the whole virtual designs increase that we've seen in the past couple of years. So I see no reasons why it couldn't adapt to future improvements of technology. I think it's quite a flexible definitions. The definition of a product and the definition of appearance are very flexible and are not linked to tangible objects. So I don't see why we couldn't have designs in the metaverse.
Brilliant. In terms of developing a viable strategy for companies, we kind of covered the part when it comes to design choice and thinking about the aspects of video games that are more suitable for design protection than others. If we're moving on to the sort of next step in the process and thinking about enforcement, again, what would be viable strategies for companies to develop when it comes to enforcement? Is there something to really look out for, something to be mindful of when thinking about design protection? Because obviously it is not enough to just identify the right type of asset and the right type of right that can protect that asset. It's necessary to think all the way through, what do I need to do as a company or as the right holder if I want to enforce that right? What is required of me? And will I, for example, be able to afford it? Will I have the necessary legal expertise to do that? Or will it require specialized advice? What are your observations when it comes to enforcement of design rights?
Sure. Shall I take this first? So a few things. First, I think it would be just interesting to highlight a case that came out in the IP Enterprise Court recently, which took an hour, just over an hour of the judge's time, and where the costs were under £20,000, which in litigation terms is extremely reasonable, although I guess not necessarily extremely reasonable by other terms. And this was really a benchmark for design litigation in the UK. It was extremely fast. Again, I know in France things are much quicker in the courts, but it can easily take 2 days or more for a case to be heard in the UK. So 1 hour or just over is very quick. And I think that's really in recognition of how designs can be, for a registered design, you're simply comparing one image with another. So there's no reason why that shouldn't be a very quick process. And the more that things are litigated, the quicker it should, in theory, become. The other important point and the real warning, I think, for people is around what's called the Alicante torpedo, where you bring into question the validity of the design at the registry level. And once it's being considered by the registry, it's not possible to bring litigation proceedings whilst that question is being determined. And that can be a very long period of time and essentially take all of the wind out of your sails as far as enforcement is concerned, because you can't rely on the design whilst the case is pending at the EU IPO. So the solution to that is to file, to start proceedings before you write your cease and desist letter. Obviously, if you're doing a takedown program, it's not really reasonable or cost effective to file a claim before every single takedown. But if it's something that maybe is a bit more high value or a bit of more of a commercial risk, then it is still worth thinking about, even for something as administrative as a takedown. The other sort of, I mean, I don't quite know how it works in France or in other European jurisdictions, but in the UK, at least, you can issue a claim without having to serve proceedings. So you have 4 months from the date of issue in which to serve, and that can give you plenty of time in which to reach a resolution. But you know that you're protected if, for whatever reason, they obtained good legal advice and took the initiative of applying to invalidate at the registry level.
So in terms of the question of validity, does that happen quite often? And I know that Emma mentioned that earlier, that some or a significant volume of the designs that are being registered are quite simplistic, which in itself calls for questions of validity. Do you think that there's perhaps opportunity to change something about that in terms of what is being registered or not? Is the threshold possibly too low when it comes to protecting design rights, which then can have this kind of negative kind of kickback in the enforcement stage?
I think the problem isn't so much the threshold that exists in the text, but rather just the fact that the EU IPO doesn't examine designs before delivering them. So the issue is that because it costs a lot of money to, you know, actually assess, is my design valid, is it not? When then it's much cheaper to just blindly try to file for tons of designs, like some actors of the video game industry have done. And it's not until you go to court that you will actually know, is my design valid or not? So I don't think that the problem is, the solution to this problem is just to examine designs at the EU IPO, because that would mean that it would be much costlier and take a lot of time to register a design. And as Rosie mentioned, one of the advantages of design is that it's quite cheap to register a design, and that's a good thing. It should be. I think that it's just as you know, as gradually people are going to be more used to seeing virtual designs, and they're going to become more used to litigating based on virtual designs, we're just going to cut off all the invalid designs quite naturally. And I don't see those invalid designs that are currently on the register as that much of a problem, because if needs be, they will be invalidated by the courts.
So
Yeah.
this kind of potential legal uncertainty, you think that it may be just temporary kind of stage where it just needs to go through determining what is valid design and what isn't, but it's not something, it's not an obstacle that would be a long-term deterrent when it comes to the industry and how much designs are used?
I think the thing is, there's no perfect option. You've got really 3 choices. The US approach, which is to heavily examine before design can be registered, which doesn't guarantee that it's still going to be valid, or, you know, it just creates a presumption of validity. The EU approach of not examining really at all, and the Australian approach, which is to make it very easy to put a design onto the register, but the moment that you want to enforce it, it goes through an additional test at the registry for validity. So they each have pros and cons and have costs that are, you know, problematic at different stages. And I don't think that there necessarily is a good or a bad answer. The good thing, I suppose, about the EU system, at least, is that every 5 years you have to pay a fee to renew it. Mm-hmm. So the really terrible designs tend to get weeded out at that stage, because quite often there isn't the economic imperative to renew those designs, and that can really reduce the numbers. Also, I mean, the maximum number of times you can renew is 5 or 4. The maximum length is 25 years. So eventually we will get to a clearer register, although obviously that's still quite a long time in video game terms, given it remains quite a young industry.
We've mentioned different approaches. We've mentioned now obviously 2 separate systems, EU and the UK. There is something such as the international design rights. If I'm a global video game company, is there an incentive for me to register a design on lots of different levels? How would I go about deciding, again, in terms of the overall IP strategy, which type of design right I should be aiming for? What are some of the advantages and disadvantages? Emma, Rosie?
I'll let Rosie go ahead if you don't mind.
Sure. I mean, so for trademarks, we have the Madrid system, which provides a level of harmonization around the world and a centralized means of applying for trademarks via WIPO. There is something similar for designs, which is under the Hague Agreement. It's not as streamlined as the Madrid Agreement. There's a lot more inconsistency. There are a lot of kind of pitfalls in terms of the time periods. So, for example, we have a 1-year grace period at the EU and UK levels, which means that you're not going to be self-anticipating by, which is a fancy way of saying, if you've launched your game, you've got a year in which to file your designs and the date that you first disclose that design through the game, whereas that doesn't necessarily apply in every other territory in the world. So I believe in Japan, for example, it's 6 months. In different countries, they'll assess where that time period runs from differently. So and that doesn't neatly link in with the Hague Agreement. So, and the sorts of things that are permitted to be covered by designs vary quite considerably between different territories as well. So I don't want to get into a long discussion on the merits of Hague, but I guess the key takeaway is that it is possible to get international protection in a similar way to the way that you can get an international registration for trademarks, but it's a lot more complicated and consequently quite a bit more expensive in my experience, not least because there tend to be a lot of local formalities that can create problems. I haven't been involved in this for these sorts of Locarno classifications. It's typically been for ones where the use of dotted lines and dashes becomes much more critical than it is for things like graphic representations. So it may be slightly easier for the video games industry than some other industries, but it requires a sensible amount of planning and not leaving it to the last minute, if that's the route that people decide to go down.
So quite high complexity to navigate, definitely requiring specialized input and advice. So one, obviously, because we've mentioned metaverse, there's no way we can avoid not mentioning NFTs. Is there any connection between designs and NFTs, and how they could possibly work together again in the video game ecosystem? How are these two linked? Can NFTs and smart contracts somehow facilitate design transactions within video games, or any other possible scenario that you envisage? Emma, do you want to take this one?
Yeah, sure. So, you know, you hear a lot about those play to earn type of games where as you play, you generate, for those who are maybe not up to date, as you play, as you generate in-game assets that you can then sell on the closed marketplace and make a profit out of you playing a video game. And apparently it's become a big thing, and it's some say it's the future, you know, the future model of video games. I think that, you know, in-game assets, as we've already discussed, is typically one of the type of assets that may be protected by a design right, and then comes into question the ownership over this in-game asset. Because obviously, even though you created it through your gameplay, somebody actually designed it, and that person is not you. And so I think that one of the problems of NFTs is that, yes, it tells you who you bought it from and who you're selling it to, but it doesn't tell you who is the first author and who was the first owner of the asset. And you know, we're already seeing some examples in other industry, like the film industry. I think it was Pulp Fiction or something, that there's been a huge litigation where they were selling NFTs of Pulp Fiction, but they didn't actually own the rights to what they were selling NFTs on. So I see that could be a risk of using NFTs.
Thanks. I think it kind of boils down to what NFTs actually are and whether they affect any of the original rights, whether economic or moral rights, depending obviously on the type of the right. Indeed, NFT as such does not prove authorship, ownership. It doesn't necessarily authenticate where that particular item, the virtual asset, where it came from. It facilitates the transaction itself and basically functions as a sort of electronic receipt, but the underlying validity or legitimacy of that transaction in the first place has nothing to necessarily do with the NFT. But do you see that, because there has been, as you said, litigations and questions in terms of how NFT transactions may potentially infringe copyright in terms of the economic rights and the moral rights of the author, but could they also potentially infringe on the design rights as well? Any sort of transaction included that includes a virtual asset of the sort of protection is also provided by design rights. Rosie.
I mean, I think it's possible, but perhaps less of a risk given the number of designs versus the scope of copyright. Probably more of an issue where you've maybe taken a screen grab where the graphical user interface is included together with other features. I thought Emma made a really interesting point around the creation of assets within a game and the ownership of that. I know that's a bit outside the scope of what we're really meant to be talking today, but it does raise some interesting points as far as, you know, whatever the contractual terms are, guiding what the relevant gamer has signed up to when they're playing the game. And I think that is the kind of the sort of hidden additional right that people often forget, is that the contractual terms can quite dramatically change what is the default position as far as ownership is concerned. And I think where designs can come into that is there is this notification requirements around registered designs, and including that or references to that within the terms is quite an important step for anybody who takes the trouble to register a design to do. that side of things, I suppose that might be where there's some additional argument around NFTs and the registrations. I'm trying to think of where there might be some crossover in practice with NFTs. I think they're still such an early right and still something that I'm not 100% convinced that they're going to be here in like 5 years' time beyond specific use cases for the art industry. I think people have been led to believe that they are purchasing something that is substantially more than what they have actually purchased. You know, i.e. ownership, as opposed to simply the right to say that they own an NFT. And I think that will create problems until we've either come up with a better system for it, or people have just got sick of the whole concept. We'll see. I mean, as a means of owning virtual assets, I think they're a really great thing. And I can definitely see that sort of tradability function within games being a really great use case. But as far as people believing that they own copyright in something, they're quite problematic, because that's definitely not what they show.
Yeah, I think they're being a bit missold as a solution to a particular problem, which they are not. We've had a question from one of the participants, which I think kind of ties into this a little bit, and it's about the notion of the informed user and how that evolves in design within video games, and again linking it to the metaverse. What is the user's level of attention, and how does the user take into account the freedom of the video game designer, which is likely to have an impact in litigation, for example, replication of the same overall impression. I don't know whether...
I think Emma deals with this brilliantly in her article, so I think she should be the person to respond.
Yeah, so the informed user is obviously a very, fact-specific assessment that is one of the reasons why there might be legal uncertainties surrounding design rights, because it's hard to determine who is going to be the informed user, what is going to be the overall impression, and so on. And so from the very few case law that we have, actually the EU IPO decisions, they tend to show that the informed user, when it comes to video game, is quite actually knowledgeable about it. Because I remember this decision regarding King icons, and I think it was a Candy Crush icon. And the EU IPO considered that the informed user was knowledgeable of different icons and was paid attention to it when they launched the app or something like that. And I thought that was quite interesting to think that the informed user of an app would pay special attention to the little icon when they launched a game, whereas I personally thought that the informed user of a video game might be a bit less, might pay a little less attention to these type of assets. So yeah, it's hard to answer because the informed user obviously is different depending on the type of design you speak of. And
do you think that the context, whether again we're talking about one of the hyper casualized mobile games, or whether we're talking about much more complex video game ecosystems, or even again metaverse, that threshold again would be somewhere else in terms of what qualifies as an informed user. You know, how much attention I'm paying as the user of that particular product or environment to the design.
I would think that depending on the type of design you are talking about, the informed user's threshold of attention should differ. I mean, that's to the best of my knowledge what they consider in other industries. So yeah, perhaps if the game isn't one of those hyper casual, perhaps the threshold of attention would be higher. I'm not quite sure. Rosie, do you have any feedback from the UK perhaps?
Well, and not specifically from the UK, but I think if you're thinking from a metaverse where the immersion level is meant to be a lot higher, there's an argument that you're paying more attention, that, you know, if the informed user is a player of the game, that their attention would be greater to whatever the design in question is, than, as you say, in a sort of hyper-casual context. I think one point that we didn't really touch on, but it's quite an important point in Emma's article, which is really, I mean, a blatant tangent from your question, Michaela, is around the fact that you can get these designs that are essentially a series of different designs that add up to an animated sequence. And that is quite an unusual feature of the graphic design, as opposed to, I don't know, I suppose it's meant to be the equivalent of getting the 7 different angles when you're looking at a 3-dimensional product. And that, where that will translate into the metaverse might be quite an interesting question, because that sort of animated sequence isn't necessarily entirely, won't work necessarily brilliantly. I'm not sure how that will translate into the metaverse. But then equally, as Emma points out, again, the way in which that limitation of having only 7 views or 7 different parts of an animated sequence doesn't neatly work in a virtual reality environment. We're actually having something that is more of a multimedia clip, or maybe even something that you can move around and manipulate to look at all different angles, might be a more useful way of looking at designs in the future. So I take back my earlier comments about there being no necessary changes, and I think that might be something that would benefit from a little bit of maybe a tweak at the policy side of things.
Yeah, I wondered whether, because a few times what has been mentioned in terms of the policies that are being drafted, perhaps recommendations and reforms of the design system, or even some of the decisions that core decisions that we've heard about today, is whether those making these decisions and drafting these policies are aware of the complexity and the sort of different levels and different types of games and different kinds of interactions that we have today, and the potential of what we can have in the future, that perhaps a user of a hyper casualized mobile game might have a slightly different threshold in terms of, you know, being an informed user than when we are talking about you know, online multiplayer game with really elaborate design, very specific design that distinguishes that game from other kinds of games and products. And I think this was one of the very few first things that that you've mentioned, Emma, is that when it comes to the proposed reform or recommendations of, you know, the changes for the design system being maintained to be viable in the future, that the video game industry did not contribute or was included in that conversation. Do you think that perhaps this in some aspects will have or could have negative impact in terms of where the reform is headed, that video game industry as such and its specificities haven't been taken into consideration by perhaps people who don't understand video games very well or can't distinguish video games from other types of industries, whether it's film industry or indeed fashion industry?
I think even though there has been no actors of the video game industry that actually took part in the process, we are lucky enough that it was, I think, I think the commission itself, through its various reports, became aware of the fact that there are some problems that are specific to the video game industry, like the limitations on the number of views and the you know to the complications that you have currently with filing dynamic designs. And actually, within the report that was made after receiving all the comments, the EU Commission really acknowledged that some of the aspects of the procedural aspects of design registration in Europe are a bit outdated, and that may be one of the factors why design isn't as popular as it should be. So I think that thankfully, even though the video game industry didn't actually take part, I do believe that the EU Commission is heading in the right way and that most of the issues will be addressed adequately.
Rosie, do you share this stance full of hope?
I'm an eternal optimist, and even 2 years of pandemic hasn't dampened that trait. So
that's brilliant. We have about 3 minutes left before the end of the session. I haven't seen any other questions in the chat, but if anybody else has a question, feel free to unmute yourself or post in the chat. And if we don't get any questions, I then propose we slowly close, bring the session to the close. It's been a fascinating discussion. There's still a couple of topics, I think, left for continuation for a next session or next opportunity to discuss designs and the role that they play or they could play within video game industry and the bright future that hopefully our session and also both of your articles in the journal has kind of helped to build and to facilitate. Thank you very much, Rosie, Emma, for being here tonight and sharing your insights and your wisdom with us. Thanks everybody for coming tonight, and thanks Christine for organizing and putting it together. It was a real pleasure talking to you, and everybody have a lovely evening wherever you are, or any other part of the day, depending on where you are, and hopefully see you all in our next event. Thank you and bye.
Excellent.
Thank you so much, Michaela.
It's been a real pleasure.
Thank you so much.